The Constitutional Court has reserved judgment in AmaBhungane Center for Investigative Journalism's challenge of the RICA laws. AmaBhungane brought the matter to the courts and won after learning that state security operatives had listened in on the phone communication of its managing partner, Sam Soul. Now, today's Constitutional Court sitting followed an application by the center to have the court confirm last year's ruling, declaring parts of RICA invalid and inconsistent with the Constitution. Let's discuss this further. We're joined by Murry Hunter. He is AmaBhungane's acting advocacy coordinator. Thank you so much for your time tonight, Murry. It's interesting because on this matter, while judgment may have been reserved, certainly on the part of the state, there doesn't seem to be full agreement in as far as it relates to the sections of RICA that need to be re-looked at, especially when you look at the Justice Department, the State Security Minister, and also, of course, the Police Minister.
Absolutely, Cathy. I think that kind of taking a step back from all of this, we've come here after a wide pattern over many years that the state spying powers, which are meant to be used to protect against serious security threats and police very serious crimes, those spying powers have been abused routinely against investigative journalists, political operatives, members of the public, civil servants, etc. And what happened today, unfortunately, is that various government agencies were at odds with each other about, firstly, disputing whether there was any problem with RICA. Some of the government departments conceded actually RICA is unconstitutional in many respects. And ultimately, every government department in the case today made serious concessions, admitting that there were serious problems, firstly, with the surveillance law, secondly, how the state has exercised that power. So it's been quite a roller coaster today.
I wonder, when you look at it, do you think there's a likelihood that the Court might actually just perhaps do what the Justice Minister is recommending, that you know, this particular piece of legislation is allowed to go back to Parliament? Or would you want some clear orders coming out of the Constitutional Court which give some level of direction as to how how RICA would need to be amended going forward?
Well, not in the prediction business, but
sure.
We've made a very strong case, I think, to the court that this earlier victory you mentioned in the High Court, which really found overwhelming in AmaBhungane's favor, should be upheld. Justice has come in late to say, please, won't you give more time? Won't you suspend all of this for more years? Our case has been to say that when we first went to court, 2017, 3 years ago, at that time, the Justice Department said, please, won't you postpone this? We're actually just about to introduce amendments to RICA. That was 3 years ago. We haven't seen any developments. They're now saying, please give us 3 years from now to address these concerns. I think there's a very strong case to say the High Court judge has said a lot of this must be fixed by Parliament, but in the meantime there must be safeguards put in place to protect against the kind of illegal spying that was turned on Sam Soul and potentially turned on many other the sorts of people who are considered troublemakers by the state.
And of course, one of your lawyers was also arguing around the structural guarantees for independence that these amendments then would almost guarantee going forward. When you look at the history of this matter and the individuals that it has affected, ultimately, it is judges who have approved some of these orders. At least that's what's required by the law. So to the extent that judges act out of their own ambit and their own volition, guided by the law, do you think that there would be a way of monitoring that? Or, is there a way of actually of monitoring it? It's the best word I can come up with right now.
It's all about monitoring. But, you know, obviously the law currently says that if the state is going to listen in on someone's private communications, it needs the approval of a judge. And as you've pointed out, one of the cases we've made is that the judge who's put in charge of overseeing those things isn't given enough independence from the executive, isn't given enough resources to do that job. And ultimately, a number of the case studies we've pointed to where those spying powers have been abused show that that single judge who's overseeing those things can sometimes be misled or sign off on a spying operation thinking that it is targeting a criminal, but it's actually targeting, for example, an investigative journalist. So we do want to see more independence built into that institution. And one of the things that we've said in the court case today is that this is not about individual judges. Is this judge independent? Is that judge independent? But ensuring that whoever sits in that seat has the kind of institutional framework they have that says this is a judge who knows that whatever decisions they take while they sit in that seat isn't going to, they're not worried about whether or not this is going to limit their prospects going forward.
Right to privacy and freedom of expression are one thing. At the same time, the duty of the state is to be able to detect and foretell any kind of threats that might occur. And that's been part of the argument that has been made from state security. So when it comes to upholding this particular order, do you think that there is no argument for state security to say, but effectively, if we go the route that these applicants are asking us to go, then those that we are spying on will know, which will prevent us from getting crucial information?
So, it's funny, AmaBhungane has been at pains from the beginning to say this is not, we're not arguing that the state should never be able to use these powers, but that there should be safeguards put in place, and have really provided all these opportunities to the state to show where it needs these powers and how it would wield them responsibly. And unfortunately, what happened today is the state was not able to provide any of that evidence. And consistently, they've argued that this is all about national security. This is all about the powers that they necessarily need to exercise. But all of these examples of how they've used them to spy on journalists who are investigating government corruption, how they spied on politicians who were seen to be threats to whoever was head of the presidency at that time, etc., etc. These powers haven't been used to keep us safer. In fact, they've been used in ways that potentially make the public less safe and have made this, the democratic climate less secure. So those arguments don't really hold water, unfortunately.
Sure. What happens in the interim as you wait for the Concord judgment?
Well, we all wait. And as it stands, the powers that existed before we went to court, which have been unfortunately used quite problematically, those sit in place. And so it will wait until the Constitutional Court comes back, either upholding our case or potentially parts of it, or saying, there's some other outcome. But until then, we're with the status quo.
All right, Murry Hunter, let's leave it there for tonight. We're going to take a short break. I'm back in a moment with your headlines, and we also take a look at more news coming up after this. We're in conversation with SAFTU's Zwelinzima Bavi.